Okay, pop quiz. What do all of these folks here have in common? Well, besides questionable hair choices, amazing hit songs, and a ton of money, they all died intestate, which means they did zero zilch nada to plan for their deaths. Now, I'm positive none of them had expiration dates on their birth certificates. I still haven't seen one yet. I've also never seen a U-Haul behind a hearse. So if they didn't plan anything, then who cleans up the mess? Who dictates who gets all their hard-earned wealth? Who actually gets that U-Haul? The houses, licenses, businesses, money, cars, etc., etc., etc. Who steps in with the backup plan? Well, guess what? It is the state in which each of them passed. If you die intestate and leave behind no directions for your heirs, the state you live in will be happy to assist in this process. In fact, Uncle Sam is happy to assist. And that process is called probate. Probate is all public record. It puts all your business out on display, who you left money to, how much, everything. How do you think we know all these celebrities died intestate? And depending on the size of your estate, or if you own property in different places, probate could take years to settle. You'll have to probate in each and every state you own property in, typically with a different attorney that is in each state as well. So you can double or triple your probate fees just from that. You can probably count on your estate paying anywhere from 4 to 7% of your gross estate, and even more in some cases. So what exactly are all those expenses? Well, you've got court fees, executor fees, attorneys, accounting, appraisals, business valuation, bond fees, miscellaneous fees. You can really see it adds up. And California in particular has one of the most expensive probate costs. In addition to your probate fees, you can incur some estate tax costs. Now, if you don't happen to have a complete set of IRS tax tables lying about, you can estimate the federal estate tax by using a quick formula. We begin with the gross value of your estate. Now, you know what? Let's highlight one of those celebrities on our first slide with a hypothetical estimate as an example. Miss Aretha Franklin. She died at age 76 from pancreatic cancer. And during her extraordinary 60-year career, Miss Franklin amassed a personal wealth of an estimated $80 million. So let's take 80 million and then subtract the current unified exemption amount of 11.58 million, then multiply that result by 40%. Excuse me? 27,368,000 in estate taxes due? Ouch. Let's knock that number down to something slightly more palatable. How about $15 million? Okay, let's just say that your gross estate is 15 million. Then we're going to subtract the current unified exemption amount of 11.58 million. Then multiply that result by 40%. Wow, we still get 1,368,000 of estate taxes due. Typically, this amount would be due within 9 months. When you don't have this amount available, sometimes it forces people to have to sell assets that they would not normally sell otherwise, like real estate or businesses. This is why it is so important to have a plan in place so that things like your home or businesses are not disrupted or sold because of your passing. Now, I know for most of us, these are unfathomable numbers. In fact, current statistics say less than 1 of every 1,000 estates will actually even exceed this number. So the question is, what if this exclusion changes in the future? Higher or lower? Well, I guess that depends on what Congress needs that tax money for, huh? I could think of a few things, especially in 2020. Now, if you complete your estimation and find out you may have an estate tax bill currently, it's possible you may benefit from estate management. Our team is happy to help explain ways to mitigate these situations.